Intellectual property has really been um, the fulcrum or the focus for the several last one decade, I would say. And towards this, a lot of changes has happened, which is of to meet the international standards in India. So when we talk of intellectual property rights, you know, uh, interestingly, our Indian statute doesn't define intellectual property rights. So when our statute does not define an intellectual, property rights or any term for that matter, what we do is we fall back on the conventions or to the organization which is kind of setting the roadmap for it. So in plain language, instead of going into the international definitions, for intellectual property, as the word says, it's a property of intellects. And rights, it gives it rights. It's as simple as it is said, it is what it is. As for World Intellectual Property Organization, it has defined intellectual property as creation of mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Similarly, TRIPS, which is the agreement on trade related aspects of intellectual property rights, which comes under the World Trade Organization, has defined again intellectual property as rights given to a person over the creation of their minds. They are usually they usually give the creator an exclusive right over the use of his or her creation for a certain period of time. So when we talk about intellectual property, the basic, very basic characteristics of IPR is that it is a creation of mind. It is intangible. And if I compare it with real estate, you can it's exactly like a real estate. It's a property, but in an intangible form. You will never be able to see it unless and until you give it another form altogether. So so this is the very basic characteristics of an intellectual property right. It gives you a monopoly over and above everybody else, all the third party rights. Nobody can have a right on your intellectual property. So it gives you a monopolistic right for a certain period of time. It also gives you the right to prevent others from using it. It gives you right to sue them by virtue of both civil provisions and criminal provisions. Intellectual property is also has a characteristic which is a bundle of rights. So one right can also turn into another form. In the following slides, I will talk about it, how that one right, one form of right can also become another right altogether. And these rights can coexist together. It could be the term of each right can vary, but they can peacefully coexist together. So just because before I get into the benefits of IPR, I thought it would be relevant that I discuss some of the main forms of IPR, which is in currently prevalent in India. So the the four pillars, like I said in the beginning, the main one are the Trademark Act, which protects the trademarks, marks, brands. It is 1999. This is the current act which we have. Then the Copyright Act. We have the Designs Act, which protects the design. Patents Act, 1970, which protects the innovations and the patents in India. There are other laws which are also growing. So the first four are, it is hardcore individualistic right. But the last one, the geographical indication, is more of a community right. So it is again a monopolistic right, but which is controlled by a set of community people. Geographical indication, as we, if just to give you an idea, is anything which relates to the geography of a country. For example, it would be, if I talk about India, we have agricultural products like basmati rice. Basmati comes from Indo-Gangetic plain. So any long grain aromatic rice which has this character in the Indo-Gangetic plain, it can be, which is long, thin, which has a particular shape. It can be basmati. So this is one. Then you have Alfonso mangoes, which again is a geographical indication in for India. We have Nagpur oranges. We have these are the agricultural products. Non-agricultural products is like fulkari, chicken work. These are non-agriculture, so it's craftsmanship. There are many allied laws which also help in protecting IP, which would be Companies Act or the Information Technology Act, which kind of comes and supports in case of any violation, also Customs Act. These are broadly the laws. Now, quickly going into what is a trademark, is any mark which is graphically representable is a mark. It has to have a source identifier. It should act as a source identifier between the manufacturer, that is the owner, and the mark. It is one of the most eye-appealing marketing tool. So under a mark, conventionally, and there are traditional marks and non-traditional marks. The traditional marks are word mark, logo, slogan mark, and non-traditional marks, which is now growing a lot, is trade dress, sound mark, shape of the goods, which are a typical marks. I've got some examples for ease. For example, now Pepsi and Sony, if we talk about Pepsi is a big brand, if we talk about Pepsi, we immediately know who is the manufacturer or the owner, brand owner of Pepsi. If you look at Sony as in this form, we know exactly who is the manufacturer. Similarly, if you look at the GE logo, you know where and who owns it. If you look at, it's I'm talking about now the last one, trade dress. Even children from a distance, when they look at the M logo, can identify that's McDonald's. So there is a great connection between a brand, a mark, and to the source. So that's a mark. Similarly, we have slogan marks, which can be protected. Again, that is, I am loving it, make believe, ideas for life, Thanda matlab Coca-Cola. These are a couple of, Dar ke aage jeet hai, some of the slogan marks, which is unique, which can be identified with the product, and the brand owner can also be protected in India. These are some non-traditional trademarks, where these are shape of goods, which can be protected. So you can see, Pepsi bottles. We have the parachute oil bottle. We have Hershey's Kisses, which is an international chocolate. So these are shape of goods. If you look at any product from a distance without a brand, also you can recognize it. It should be that the consumer who's picking it from a distance can pick it up even without the brand. So that should be the identifier. I mean, that should how you should, the mark should connect with the owner. We also can protect sound marks in India. So let me just see if I can play it. So this is a Tarzan yell, some example which of sound mark which can be protected in India. So when you play these, sounds, you can actually relate with the owner again. It's it doesn't. Sorry. So these are some of the examples. In fact, we've also had one example where the Taj Hotel in Mumbai is one of the shape which has got protected in India. So that is again something which can be protected. In India, we can also protect well-known marks. If a mark has acquired great recognition, apart from the goods it is recognized for, it can also be protected across all the classes. For example, if I am in the Pepsi's in the food segment, we have about 45 classes. If it's in the food segment, like for example, it is 2930, Pepsi can be protected for all classes from 1 to 45 if it is a well-known, it is recognized as a well-known mark. For that, there is a procedure now. So I'm not going into it. If somebody is interested, we can always talk about it later. Now, what is the copyright? It's a protection of creativity. It is it can cover literary work, dramatic work, artistic work, musical work, cinematographic work, sound recordings. Copyright again is a bundle of rights. There need not be, it may not be novel in its in itself. There can be one idea which can be created by several. There is no copyright in ideas, but of course, if it is put, the concept is put into a good form, there is sufficient labor, effort, it can be protected. For example, a novel can be also exploited to be made into a movie, into a play. It has several forms that it can take. Okay, so we go into designs. Design again is anything which is it is visually appealable, which is basically a shape of the product. It does not have any functionality. It should not be a trademark. It should not have any patent implications in it, which means that it has to be only eye appeal. For that, you go for design protection. In case of design, the moment there is always this. I think I'll mention here that if you create a design, you need to first, before you make it public, you need to register it. I'm going to say that here because I know there are people who are in the design segment here. So people do tend to get confused. What they feel is that let's publish it and we can always protect it later. But in case of design and in case of patents, which I'll be talking about, novelty is the key. You have to protect it. That means when we talk about protection, at least we have to apply for that design and for patent even before you make it public. It cannot be that you publish it in a magazine or in a brochure or launch it in a exhibition, you know, and then go for application. It has to be, you know, you have to apply first and then publish it. If you don't do that, your design is lost. So novelty is a key in case of designs, which is not the case for trademark and for copyright. As for patents are concerned, these are all inventions. Inventions which cover that are covered under patents are, you know, it can be pharmaceutical, it can be mechanical, it can be electronic, it can be, it can, software per se is not covered under patents, but if it has a technical outcome, it can be protected. It has to be novel. It should be non-obvious. These are the key characteristics for protection of a patent. And it should be something which you can put it to industrial use. These are key takeaways for a patent protection. Now coming to whether you know, when we have an IP, what needs to be done? I've just put a few takeaways on this slide. For trademark, of course, registration is not mandatory. India is a common law country where use has a better right than registration. But having said that, registration is advisable because it confirms your rights. Similarly for, okay, let me just finish trademark. So for the term for a registration of a trademark is 10 years. You can keep renewing it, and it can be perpetual. You can, so long as you can renew it every 10 years, it has a life. Unless it is cancelled by a third party or for non-use or for something else, you can enjoy the fruits of a brand. I mean, there are brands which have gone for over 100 years, 200 years. We know of so many of them. And for trademark, it is a territorial right. It is meant only within, if it is registered in India, it is only meant for use in India. If you want to use a brand for exports, you will have to seek protection in that particular country. So you will have to you'll run through the entire procedure of protection, registration in that particular country as well. For copyright, you don't again need any registration, but again advisable because it defines your rights. It's a document which confirms that you are the owner of that copyright. It comes into existence the moment it is published. If you've kept it inside a book and, you know, if it's a novel, you've kept it with you and it's not been published, then it does not have a copyright. To have a copyright, it has to come into existence, which means it has to be pushed to the public domain. The life of a copyright is it is the life of the author and 60 years. Copyright again is global. Because India is a member of the Berne Convention and several the Universal Convention, Copyright Convention, which gives the member country the same right in those member countries which is available in that country. So once you have a copyright in India, you can be protected under the Berne Convention and UCC in the member countries. Design, you need to have a registration before you publish it. So it is advisable to register before you publish. The term for design is 10 plus 5 years. So 10 years is one slot of validity, and then you have to renew it and you're given 5 more years. Again, design is territorial. Any country beyond India you want to protect, you will have to seek registration in those countries before you launch your product. Patents, again, you need registration. Registration is mandatory. It has you before you publish it, and the term for it is 20 years from the date of application. So you will the countries where you want to market your patents, you will need to go and seek first seek clearances for all those countries and then apply for it. Again, patents and design both are territorial. So some of the IPs are overlapping also. Some, for example, something which is covered under, just for example, a design, a logo, which is an artistic work, can have an overlap relation between trademark and copyright. Similarly, something which a design which has over the years has acquired a trademark significance. People start identify a certain product with a particular manufacturer. It can, after the expiry of the term of a design, can continue its life as a trademark. So those are some scenarios where you do have an overlap of IP. Okay, so in the beginning we were discussing why an IP is necessary, and it was very well summed up by the entire team here that it actually encourages innovators. It takes away the fear of being looted or robbed of its fruits of labor. So when an innovator puts his time, effort, and money into creating something, at least one should give that innovator some time to make at least good of the investment made, and also to earn some more so that they can start creating something else. For example, if it is a cancer drug, many pharmaceutical companies, they have the best of research and development labs, the best of the minds coming and innovating. There are several tests and errors which are done. These research run for more than 5 to 10 years. It's never easy to innovate life-saving drug. So at least we should protect their effort. So therefore, they are motivated to invest. Big companies don't get motivated if they're robbed of their efforts. So therefore, to build their confidence, you can tell them, okay, you create a patent, you have 20 years to exploit it and make your money. After that, it goes into public domain. And it is also good for the economy because it gives a lot of jobs to a lot of R&D people. Then it is converted into a product. The brand is sold. So I think it's a good way of also making money. So when we talk about what is the benefit of it gives to the owner, it gives when you talk about brands, it gives a competitive edge to a brand owner because it gets recognized. For today, if you ask, the biggest, how Google has its edge over Facebook, similarly YouTube or WhatsApp. So everybody has this competitive edge. It is if you talk about in the food segment itself, Coca-Cola and Pepsi, constant battle. They all have a competitive edge over one over the other. We talk about, it is again, like I've already spoken, it's a good way to protect your investment time. Um, for the time, if you the money that you entrepreneur has spent, it should also reap it. So therefore, it is absolutely necessary for the owners. Again, we can exploit it during the term of the IP. You can always license it. One of the biggest money churners has I've been a part of many amalgamation, mergers, demergers, acquisitions, licensing. It is, if you have a good brand, you can always license it, you can always sell it, you can break it into several parts and sell it. For example, a copyright, you can sell it, make a movie out of it. From a literary work, from a novel, a movie can be made. Then you can also give it to Netflix or Amazon Prime, make more money out of it. If it is a character, a cartoon character, you can make merchandise out of it. So it can be, you can create several other IPs. Also, you can make a lot of more money out of that. Apart from that, I would say that protecting an IPR, again, it gives you a, a satisfaction or a comfort that your IP is well taken care. The laws will protect you in case the third party is violating it. I must say here that in India, we have a very well defined IP laws, and the courts today in the last 2 odd decades have been very well educated, and the IP owners are very well protected. Having been a part of many such cases, I've seen there's no national biases or international biases or deep pocket biases. If it is you're the owner, even if it is a small scale company or a startup, will be protected if it is a big multinational trying to bully you. So that is one, and the last but not the least is also IPR, which, because it has a value, you can always mortgage it. But these days, banks, having had burnt their fingers with Mr. Mallya's Kingfisher brand, they are a little reluctant in India. But yes, IPR, it has a value. If it's well protected, it has a brand, it has a great recognition, you can always take loan against the said IP. So some of the, before I close the presentation, I think some takeaways for protection of IPR will be that when you establish an organization, or when you are thinking about an organization, from that very beginning, you will have several IPs which come into your mind. It can be a trademark, it could be a design, it could be something which is covered under patents. So you need to recognize what your IPs would be. You will need to discuss it with your IP specialists, lawyers, and seek their advice as to how to protect it even before you launch it. Be it a trademark, be it design or patents, so that there is some due diligence and clearances done for you, and you're well protected. Apply for your IP is very important in India and in the countries where you would like to expand to. If you have a good IP lawyer, they will be vigilant for you, because they have systems to keep an eye for any third party violations of your IP. For example, if it's a brand, they have internal systems, journals, and which are reviewed on a regular basis. Similarly, they have investigators who are in the market who keep an eye for your brands. Uh, and, and one should never be shy of taking action. There are ways and methods to kind of controlling any violations. Like search, you could always give a CND and notice for violation even before you go to the court, if required be. So you need to protect it. It is very important that before it's stolen, it is diluted in the market. You have to protect what belongs to you. And last but not the least is a couple of IPs which have a renewal term. You need to continue to renew it. So that's the brief summary, and I'm open to take questions.